welcome back to Senate Education, Tuesday, February 28th, 2:07. Ms. Yang, thanks again for joining us. We really appreciate it. Those of you who haven't had the opportunity, Bora Yang is the Executive Director and Counsel of the Vermont Human Rights Commission, and just a great resource for all of us as things might pop up legislatively or with our constituents. So thanks so much for being here. An act relating to miscellaneous changes to education law is what you are here to say a few words about. And so I'm not sure how this whole thing happened. I know your name was mentioned a couple times last week. We're just glad you're here. And so the floor is yours.
Thank you so much. I am really glad to be here too. I had hoped to join you today, but alas, the weather. It's a little bit different from a few years ago when I was scheduled to testify in a committee and my car got stuck in a ditch in the middle of winter. So I had to miss that testimony, but I was very grateful for the opportunity to come today before your committee, even if it's virtually. So again, for the record, my name is Bora. I am the Executive Director and Legal Counsel for the Vermont Human Rights Commission, and we enforce the anti-discrimination laws in the state of Vermont, including the Public Accommodations Act, which covers all schools in the state. And I want to thank you for this opportunity. I want to talk a little bit about harassment in schools today. But before I do that, I want to give you just some context in history about harassment. So harassment is a form of discrimination. And as a legal theory, it came about through case law, not statute. And it was widely adopted after the 1986 U.S. Supreme Court case called Meritor Savings Bank versus Vinson. And in that case, Michelle Vinson was an African-American woman who had survived extreme sexual harassment at the hands of her supervisor over like a 4-year time period. And we're talking about 40 to 50 instances of rape and groping, demands for sexual favors, and a lot worse than that too as well. The case presented some very extreme circumstances, and the U.S. Supreme Court held that this type of hostile work environment has to be a form of sex discrimination. And the court articulated a legal standard in that case that said that harassment has to be severe or pervasive. And in Michelle Vinson's case, she could prove that it was both. However, the U.S. Supreme Court did not clarify what type of behavior, short of the 40, 50 instances of rape, would meet the standard of severe. And it did not articulate how much and how long harassment behavior had to occur for it to meet the requirement of it being sufficiently pervasive. In fact, at one point, our own court, the Vermont Supreme Court, even got it wrong. In a student rape case, the Vermont Supreme Court articulated that the standard was severe and pervasive. And a Vermont court postured that a university student who had been raped may not even be able to meet that standard because it hadn't happened more than the one time. She ended up losing on procedural grounds, and that has since been corrected. But throughout the country, courts have been grappling with the definition of severe or pervasive and that legal standard. And there have been many, many instances in which girls and women and people of color, people with disabilities, have been subjected to stalking, racial epithets, sexual innuendos, and they have lost their cases because the courts have found that it wasn't sufficiently severe or pervasive. I'm just going to give you a couple of examples. In the Fifth Circuit, a woman by the name of Sonia Barnett lost her case, even though her supervisor touched her sexually inappropriately, intimidated her, stalked her. The court said, well, yeah, all of that happened, but it didn't destroy her ability to succeed in the workplace environment. In another case, a coworker had made comments about LaDonna Hockman's body, slapping her on the behind, grabbing and brushing against her breast, trying to kiss her for over a year and a half. And the court said it was not severe or pervasive. In a different circuit, in the 11th Circuit, in the case of Mitchell versus Pope, for 4 years, a supervisor subjected her to 16 separate incidents of harassment, and the court said 16 over 4 years, not that frequent, not pervasive. And I could go on and on and on. And so why am I telling you, the members of the Senate Education Committee, about these workplace harassment cases? Like, why does that matter to you? Because these are the cases that are relied upon interpreting harassment in schools. Judges and lawyers must follow the precedents that these cases have set. And the severe and pervasive standard is actually adopted and articulated in Title 16 of the education laws. The other problem is with severe and pervasive is that courts don't know how to consider the totality of circumstances when they're analyzing claims brought by a plaintiff who belongs in multiple protected classes. For example, a woman of color who also has a disability must independently prove that she suffered severe or pervasive harassment on each of those bases. So if a perpetrator is calling her racial slurs or making sexist comments or continuously causing her to fall or trip because of her physical disability, the court views each of those instances separately to see if there was enough racial slurs to meet severe or pervasive, enough sexist comments to meet severe or pervasive, enough causing her to trip or fall to meet severe or pervasive. The courts don't know how to view all of those instances in totality. Had they been able to do that, it's possible that all of them could meet the standard of severe or pervasive. Last year, the legislature adopted a new standard in housing. They got rid of severe or pervasive. They adopted a new standard in housing that looked at the totality of circumstances, that says we're not going to consider severe or pervasive anymore. We're going to look at the way that harassment truly occurs for people in housing. And because of that change in the law, we had a case at the Human Rights Commission that reached a final determination that discrimination had occurred when there was a tenant who was subjected to ongoing harassment because of her disability, because of her sex, and because she was receiving public assistance. And I can tell you that that case would not have reached the final determination of discrimination if that law had not changed. So the ask before you today is to really correct a standard that has gone awry. It is to adopt a standard in Vermont that will capture more meritorious cases that have lost before they've even made it to the jury. It is to uphold a standard for our students across Vermont that says you should not be subjected to groping, you should not be subjected to racial slurs or sexist comments or statements about your disability or homophobic statements when you are at school trying to learn. Adopting a new legal standard is important because people teach to the law. Schools teach to the law. They teach compliance. A new law adopts a new standard for behavior in schools, for investigations, and when schools should be opening investigations, for teaching and learning about appropriate behavior. So I just want to quickly, and I don't have a lot of time, I just want to sum up why severe pervasive is not a good legal standard, why we need to be looking at harassment differently. Again, it's unclear and inconsistently applied. It sets an unreasonably high burden for plaintiffs, but those plaintiffs are not even getting to the jury or judges to hear their cases. Women of color, individuals with intersectional identities are particularly vulnerable to harassment. Judges don't know how to look at the totality of circumstances. And again, schools rely on the law to dictate what they will investigate, what they will correct, where their resources will go for prevention. And they rely on the severe pervasive standard to govern their behavior. I think it's time that we adopt a standard that reflects what we expect in a fair and equitable and inclusive school environment. And I would love to see this committee take this up. So thank you. I'm happy to answer any questions that you have.
Well, first of all, thank you. This is really helpful. Reminds me that we should have you in more often. Why is it in Title 16? And I'm sorry for being ignorant. Whenever I think of Title 16, I think just about all of its education law.
Right. So Title 16 also has harassment laws in schools. And so it adopted the existing standard at
Yeah.
that time. Yes.
So do harassment standards exist in other parts of law, or is it all in titles? I suspect it's throughout the state, right? Different law.
So harassment is a form of discrimination, and because of case law, it's captured in all of our anti-discrimination laws. So in our Fair Employment Practices Act, it's there. It's under our fair housing laws. It's also under our public accommodations law. And remember, public accommodations also include schools. But in addition to that, Title 16 goes further and actually codifies severe or pervasive in its own education laws as well. So there are already existing bills, both in the House and in the Senate, that seeks to change public accommodations law and seeks to start a new legal standard for looking at harassment. But we must also bring along with those changes our kids in our schools and making sure that the rules that we apply for harassment in the workplace and in our stores and our hospitals is also the same rules that we apply to the kids in our schools. Young girls who are experiencing harassment in schools should not be subjected to a higher, different standard than women in the workplace or tenants in housing.
Or could I ask you to send us some language?
Absolutely. I have the language, yes. And the language is the language that is in those existing bills.
Sure, I have it. I just haven't.
Yes, and in those housing bills. But I believe I believe Damian Leonard is the ledge counsel charged with these changes. And I don't know if that's your ledge counsel for Senate Education, but I'm happy to send them the language that we've been looking at. But they would be very familiar with it if you're interested in adopting this.
I would be really grateful if you would send us some language and to Ms. St. James, to the committee, Mr. Leonard, and then it'll at least give us somewhere to start. Senator Gulick.
Yeah, we have time for questions.
Oh, yeah, absolutely.
Yeah, okay, great. Thank you so much for your testimony. It was really educational for me and also troubling on many levels. I'm just wondering if we were to correct the standard and establish a new one, what kinds of outcomes you would hope to see sort of downstream within an educational system?
Yeah, so I think we would be filling in a lot of the gaps that currently exist. So one of those I already mentioned, which is the fact that courts don't know how to look at people who have intersectional identities. And so one of the things that first and foremost is that someone who belongs in multiple classes, protected classes, would be able to say, if you look at my whole history, you would see that it's the same perpetrator who is using different language at different times, but they are harassing me because of all of these protected classes. So that would fill in the gap for those groups of people for sure. But also, I know as a matter of fact, through our investigation, that schools do not look at the big picture when they're investigating cases. So I'll give you an example. Someone says, I was called a racial slur in the classroom. And then schools will investigate that incident, but they may not open an investigation into the history of how often has this happened? How long do you know this person? Has this been ongoing in the bus? Has this occurred elsewhere? Has this occurred on the football field or anything like that? And setting a new standard says that we are going to start looking at not just each incident, but the total of incidents and the relationship between students. And so it allows us to really start with new, fresh eyes when we're looking at harassment in our schools and to set different behaviors for how students should behave in schools and what schools should be responding to.
Thank you.
Yes, Senator Williams.
Just the treatment that you're talking about in the schools is coming from students, correct?
Yes, but it could come from teachers as well. But yes, most of the time it's student on student harassment.
So legal action can you take against students? If they're 16 years old, for example.
Right, yeah. So our harassment standard is really, so when a student actually engages like criminal behavior or physical assault, other than a civil action or a criminal prosecution, this is not what I'm this is not what I'm talking. This is about holding a school legally accountable for when they are on notice and they fail to address something. So this is about holding schools accountable for when they're on notice that harassment is occurring and they're not addressing it or addressing it fully, or they fail to put procedures in place to protect kids from the harassment.
Thank you.
Yeah.
So I think a starting point, again, if you don't mind, you would send us some language that we could review and look at as a committee. Senator Bueller.
All right, one other question. Do you think, looking at when we investigate, we talked about investigating and not just looking at a one incident, but across a broader landscape, are we getting into FERPA when we do this, and might we need to? No? Okay. Rachel.
I mean, FERPA is always, in terms of confidentiality and ensuring confidentiality, is always important. But no, the schools still have an obligation to review it and investigate it. Yeah, FERPA is really about, do you get to hear the names of the people that reveal, instances, or can we? It's really about confidentiality, but the duty to investigate already exists, and schools are required to do it.
Okay, thank you.
Or do you know where the bill is in the Senate?
I believe it's in the Senate Economics,
Okay,
and I want to say it's S103. And the House has a companion bill called H359, I believe.
so I'll talk with Senator Rom Hinsdale to see if she thinks she's gonna move it before crossover. If she doesn't, there's still another way to get it done this year. Then I just have to think about it. So we'll start with your language. There might be another thing to it. I feel like it's a standalone bill, frankly. It doesn't seem to be like, something I want to attach to a miscellaneous bill, but there might be some other way to do this year, so we don't have to wait until next year.
Yeah, thank you so much. I believe that the bill in Senate Economics addresses public accommodations changes, which again incorporate schools, but it is your purview to address Title 16. And so, yes, if you are able to work on it together, that certainly would make the most sense, most reasonable.
Senator Williams.
Just one more thing. Is there any kind of a cause and effect analysis of why this is happening? I mean, if there's a mechanism like cell phones, there is a lot of harassing and through social media. Could we consider doing something like telling them not to bring your cell phone to school? I mean, that might be we always look for prevention for anything that we do. You got to look at the root cause. What's the common denominator?
Mm-hmm.
I mean, teachers probably don't do something they should sometime because they're afraid of repercussions if they do. So I'm just looking for a cause and effect analysis of what you think is happening, what is happening. Yeah.
Is there an article out there, Bohr, that you've seen over the years, or some research that might just kind of give us a sense of as Senator Williams, and I don't want to put words in his mouth here, but the culture, what's happening in American society that might help us all to understand it. We could even possibly get the author or the social scientist in to take us through. So if you see something like that, that would be great. And probably us.
Here's the reality is that harassment and discrimination has been long part of our history and our society. It has been made worse through social media platforms. Yeah. And so kids have no escape. It used to be in the old days that when you were bullied or harassed, by a kid, you'd come home and get some reprieve or on the weekends. And now it is happening all of the time, everywhere and every place. But the cell phones or the screens or the social media platforms is just the mechanism for kids to do what they've always done. And the key is that, and I mentioned this a little bit, is that we have to be teaching and setting a standard in our schools about the bad behavior. So it isn't just getting rid of the cell phone, but why sending a picture or sharing a text message that is private, that a girl sends to her boyfriend over and over and over again, is inappropriate and wrong. And what's happening is that our schools are teaching to the law, and the law says not severe or pervasive. And we need to teach to appropriate and best behavior. And we need to change that law so that schools are teaching to a law that actually reflects what we expect of kids in our schools. And that's why I think it's important to address the teaching element of it as well, if we are changing the legal standard around it.
I completely agree with the focus on the teaching. I want to just add, I want to make sure I say this right. I think another level of complexity is that school districts are really loath to discipline harshly. Let's put it that way. We're trying to lower the number of expulsions. We're trying to lower the punitive nature of the way we handle conflict, working toward more restorative practices and so on and so forth. So I guess I'm trying to get all of this straight. It's complicated.
It absolutely is. And you're right to be thinking about that. And I want to say that nothing I have mentioned is about expulsion or suspensions or kicking kids out of school in any way. And this is about holding a school accountable for when they are on notice about harassment and needing to do something. There are many things that a school can actually do that is short of expulsion and suspensions. That kind of discipline is not the only mechanism for schools to address harassment. In fact, it is probably not the best mechanism for addressing harassment. Could you move a kid's school bus stop? Could you separate kids? Could you ensure that there's an adult that is observing what is happening in the classroom aside from the teacher who's teaching the core curriculum? Can you create a safety plan short of expulsion and suspension that ensures that kids on the playground, that there's extra eyes on the playground, or that there's a safety plan where kids are coming to and from the school at different times? And if you can't do that because you're dealing with the smallest school in the state of Vermont with very few kids, very few teachers, is that could you offer a safety plan that allows that child to go to a different school? Could you do that, right? So we're talking about schools thinking about all the different tools, using all the different tools that they have, short of expulsion or suspension, to address harassment. And right now, I will tell you, most of those tools are not explored, because when they hear of quote unquote an allegation of harassment, they immediately go, it's not severe or pervasive. It's not our duty. We're not addressing it. And so that's what I mean about even getting them to a place where they're exploring all the possible tools that are available to them. So yes, this is not about disciplining first graders in that way. I don't mean to suggest that, or even ninth graders in that way, right?
Thank you so much for clarifying that.
Yeah.
That was really helpful. I appreciate that.
Absolutely.
Laura, thank you very much for joining us and
Thank you.
Bringing this to our attention, and we'll look forward to receiving an email from you, but also look forward to working with you. And maybe we can touch base later this week, prior or during maybe town meeting week, just to come up with a plan on how to best move this forward this year, if we can do that. And I'll touch base with Senator Ron Hinsdale as well.
Perfect. I would love to do that. Thank you so much.
Thank you.
Really appreciate your time.
You bet.
Take care.
You too. Ms. Seelig. Leave it to us?
Yes.
You are. Oh, nice.
He's one of the folks
You know,
struck down with COVID right now.
Oh, he has COVID.
Yeah.
You'll interact with him housing,
Yeah.
and conservation.
Oh. He runs the housing and conservation
know.
board.
Yes.
Everyone knows him.
Yeah.
And I don't mean to get personal.
No. I
It's,
think,
you know,
I'm pretty sure most people in this building assume that or ask that, so that I have no problem being associated with you.
Yeah, no, he's a good person to be associated with. Okay, so, we have about 25 minutes. People might want to stretch before, so we don't have an awful lot of time. I think first and foremost, we need to see and understand the conversations you were able to have, if you were able to have them with the Agency of Education around some language. And I don't know if Dee is joining us as well. Is here? Oh, Dee, great.
So
Hi, Dee. Great.
First for the record, Rachel Seelig, Director of the Disability Law Project at Vermont Legal Aid. I did have a conversation with AOE's General Counsel, Emily Simmons, yesterday.
Great.
Good conversation. I had not finished drafting language yet, which I was able to send to you all at that 8:39 last night. So she has not had a chance to see this yet, and I think what I would say is that we agree that there needs to be improved fidelity to standards, but we do not agree on whether behavioral threat assessment teams are the way to do that. So that's kind of the context that I would have for you.
So let's, we might not go deep right now, because I don't want to go too deep without having the time, so we might have to continue this tomorrow, but so you're in a disagreement around behavioral threat assessment teams themselves. So I can just say anecdotally, having visited my local middle school yesterday, and they told me about their behavioral assessment team. I left impressed. I left like, okay, wow, this seems like a good group of people. It seems like they're coming together on these issues. They've been doing it for a long time. So what's not working that you would say?
Sure. So I want to kind of back up a second.
Great.
Just to say, first of all, we absolutely support ensuring school safety, right? Like that is a key priority. We want to prevent the kind of catastrophic events that have happened elsewhere at risk of happening here. The problem with behavioral threat assessment teams is that students of color and students with disabilities are disproportionately targeted by these teams as they are implemented around the country. So, and the reason for this is I think complex. But what we have seen is that just as there is currently an issue of practicing with fidelity the rules around when a student is disciplined through suspension or expulsion, that in places where these behavioral threat assessment teams are in place, they're not necessarily done with fidelity, right? And so that the same problem that we have is a problem for these teams. It also pulls law enforcement into the school and the student's life when that's not really necessarily what we want. You know, we've talked a lot about getting police out of schools. And so that's another problem with these teams. And fundamentally, I think the biggest problem with some of these teams is that they offer an end run around the procedural due process rights that students have when there's a consideration of removing a student from school. And so they come a way to suspend the students off the books or kind of do what we've also called informal removals. And I have some resources that are some studies that kind of corroborated some of the disproportionate impact of these teams. And so that's one piece of the background. And then I think the other piece is what are the major issues that our schools are facing when it comes to problem behaviors in school. And the vast majority of the reason that students are removed from school are for school conduct violations and fighting. And so issues of threats or intimidation, danger to self or others, property damage, assault or battery, weapons possession, those are much less frequent occurrences. And so to have behavioral threat assessment teams without defining what their role is or when it is appropriate for a student's behavior to be sent to them is a problem. And to not define how
they fit in with restorative justice practices, or suspension or exclusion practices, or hazing, harassment, and bullying investigations. I think the vagueness here is a real problem. So that's kind of the second piece of context here. And the third is that schools already have the power for students who pose an immediate threat to remove that student, or in fact take whatever action is appropriate under the circumstances, provided they do a hearing on that school removal as soon as possible afterwards. And the reality on the ground that we see is that hearing doesn't happen. That most of the times, either it doesn't happen, or if it happens, it doesn't happen with all of the procedural safeguards that there's a right to, such as a written decision as to why you're being removed from school, or an opportunity for the student to tell their side of the story. And I think this just takes us in a different direction than we've been moving with positive behavior interventions and supports and multi-tiered systems of support that go to your question earlier with harassment about solving, prevention, right? Solving the problem by preventing there being a problem. And so when I see the disproportionate impact of school discipline on low-income students, students who receive free or reduced lunch, on students with disabilities, what I see is that we need to better support our students and the teachers who are supporting our students, not create another pathway to remove students from school. So that's kind of the fundamental problem that I have with behavioral threat assessments. The proposed language that I sent you, one would define behavioral threat assessment, and I would say it's a really rough definition because it was a fairly short turnaround when I was with you all last week. And so I'm very open to suggestions or changes on that. But I think the key is that we don't create a lower threshold here for what a threat is than what already exists in other law, right? We have Rule 4500, which governs restraint or seclusion. And so we already have kind of a standard of when we can deprive a student of their liberty in terms of their ability to move their own body. And to have threat assessment teams look at behaviors that are less than what you can be restrained or secluded for, to me would be a problem. So, so that's one piece of kind of trying to define this is what is actually a threat that would be considered. And then the second is, rather than having this kind of separate mechanism of behavioral threat assessment teams that don't necessarily know the student, to use the existing teams that exist for many, many students, whether those are IEP teams or 504 teams or educational support teams or coordinated services plan teams between the school and mental health services and other services, that those are the people who know a child and are going to be in the best place to say, we don't understand where this behavior is coming from. We should do a functional behavioral assessment and understand what the function of this behavior was, and if we should implement a behavior plan in order to address the behavior and prevent recurrence. And have a team who knows the child be considering, is this a child who needs to be removed from the educational setting for a short period of time, for a longer period of time? Do they need a different educational setting?
So what I'm trying to, and I'm sorry to interrupt, because
No,
I do know
please.
we're gonna get
Yeah,
cut
yeah.
off, and I don't wanna dig too deep where we feel like we can start again tomorrow, but
Yeah.
I think what the governor's office and others were looking for was something, a nimble sort of, this is a crisis situation right now. We have the student and the team in the behavioral threat assessment would, just thinking about what I experienced yesterday in my middle school, has a range of people with backgrounds, knowing the size of the school, someone who's going to know the student, to kind of prevent some of the things that you're talking about from happening, and also keeping everybody safe
Yeah, and I think that
in like an emergency situation.
Sure,
Yeah.
and I think that that's already permitted under the suspension and expulsion rules, that if a student in an emergency poses an immediate threat,
Yep.
that student can be removed. So I think, given that power already exists, creating a separate team involving law enforcement in that team criminalizes potentially disability-related behavior, tends to target students of color, students with disabilities, low-income students. And so that, to me, if the power is already there to respond to an emergency by removing a student emergently and then providing a hearing afterwards. So to have these teams without defining, oh, well, what this team's purpose is to do is to say, oh, this student, there is an emergency. Like, if that's what the purpose is, that's much less of a concern. But right now, the purpose is not defined. The purpose of these teams is quite vague. And that what we've seen in other states is that that has created significant mission creep, where again, police are in schools and are kind of policing what is, you know, developmentally appropriate behavior that needs to be taught, and skills need to be built rather than criminalizing children's behavior.
Yes.
So I guess I'm confused. So what makes up these, who makes up these assessment teams? Are they teachers?
So the proposal here would include a building that you have before you, would include, I believe, building administrators, school mental health professionals, law enforcement, primarily.
A nurse, I think a
I
school
think
nurse.
you're right, I think a school nurse is in there as well. But not the parent of the student, not other people who are familiar with the student. If the
You don't
student's on
support that?
IEP, not a case manager. I don't, I think that
Okay.
decisions, I mean, the way that the IDEA is written is that for students with disabilities, it's a team of people who know the child who make these decisions.
Okay.
And I don't think there's really a good policy reason to have people who don't know a child, whether they have or don't have a disability, making this kind of a determination.
Yeah, so I'll equate it to follow-up question.
Yeah.
We had, you know, safety is everybody's business.
Sure.
So when it's everybody's business, nobody in particular is looking at it. So if we got a team made up of, you know, people that aren't sitting there and actually observing what's going on, the bullying, with harassment, what's the right combination? Who's supposed to be responsible?
Yeah, I mean, schools do have people that are designated to assess bullying and harassment, investigate bullying and harassment incidents. I do think the people who are designated need to actually be trained on how to do those investigations, because there's not a training
Oh, yeah.
requirement right now. And have support, you know, I would love to see like a designated position at the agency to be working on positive behavior interventions, safe and inclusive schools, case and harassment, bullying, all those things. But again, I think it's, to your point earlier, more about setting up schools to be able to prevent students from getting to a place where they might be a threat, rather than assuming we're not going to meet their need, we're not going to meet their need. Now that instead of being a member of our community, they are a threat to our community. And that unfortunately is what we see with our clients. You know, we had a 7-year-old who was not allowed to be suspended last year, because of using a pair of safety scissors and shaking them towards another student. And that student, we didn't get back in school for months. And the district insisted the student was not suspended because it wasn't disciplinary. And that's just not correct. When a student is removed from school, that is a suspension or expulsion. And we had to take that to the agency to have them take a look at that situation and agree that that student had been suspended and been denied their right to free appropriate public education.
Was there a hearing in that?
No, there was never a hearing provided, and we were involved.
So we talked to a Sunday morning at breakfast.
Yeah.
Somebody came up to us and said, you guys have got to do something. She was a behavioral, what was her intervention?
Interventions, yeah.
And I said, well, and I mean, she really let us have it. It's like, it was, you know, our fault. And I said, whoa, you know, you need to explain it to us, because I don't totally understand what the problem. It was a local school. And I said, well, why don't you come and try and get on and give us testimony in the education committee? It ends up being crosses over into health and welfare as well. And she didn't know anything about that. And I said, well, if you got something to add, don't sit there and keep it to yourself. You got to spread it to where we can do it, make a difference. And,
What was the
and that's
gist?
for
What was the gist of what she was saying?
that in her school, that nobody utilized her the way that she was trained to be used. And she was also a coach, and she was, you know, so she sees it from different angles within the school. Structure.
And I think that goes to good implementation of the services and supports that we have, right? That, you know, in 2007, I think 3 schools in Vermont used positive behavior intervention and supports, and now we're up to 168. So that's progress, as long as that's being done with fidelity, right? And that people like a behavioral interventionist are being used in a way that is actually helpful to students and to improving the culture in the school. So that it's
She's
safe
losing her
and inclusive.
job. That was,
Oh,
that
that's
was,
terrible.
that was the reason that she was upset,
Yeah.
because they viewed her position as not necessary.
So before we go to Ms. Barbic, can you tell us simply the areas you agree and the areas you disagree
So
from your perspective?
So all of the sections on the drills, all of that right up to the behavioral threat assessment team. And so the behavioral threat assessment team is the
Okay,
area
so
of
just to, we have, as you can imagine, a zillion footballs in the air right now. So I
Yes.
just want to make sure we're on the same page. So if we are looking at the version of 3.1.
Yeah.
You are in agreement on, tell me what pages,
So
1 through.
1 through to page 4, line 5 or 5. It's line 6
That
through
is
line 19.
Very helpful. So, and what you're proposing to do is to substitute what you have submitted today
Yes.
from there on.
Right, and again, that would create definitions of what is a threat. It would create a definition of a manifestation determination review team and expand it from what is already required under federal law to not only students with disabilities, but all students. And then it would provide a process for manifestation determination. And I think fundamentally, it would make sure that if a student could benefit from a plan, whether it's 504 plan, IEP, educational support team, coordinated services plan, that's what we do, rather than remove the student from school or provide other services and supports. Because what we have seen again across the country is that even if these teams aren't intended necessarily to remove students from school, what their effect is they are removing students from school.
Ms. Barbic, thank you for joining us. So as you just heard, helps me sort of get my head around it. You're all in agreement up to, you're in disagreement around section 4.
Yeah.
And so for senators and those watching, that is draft 3.1. It is section 4 where there is a difference of opinion. And we have Ms. Barbic with us. Would you mind introducing yourself and letting us know your thoughts?
Thank you, Mr. Chair. My name is Dee Barbic. I'm the Director of Violence Prevention for the state. And thank you again for the opportunity to come in and listen to testimony and speak on this section and these sections of our school safety language. And, you know, I do appreciate the commentary and the testimony given. I noticed that the focus has been a lot on removal of students from schools. And I just want to clarify that behavioral threat assessments are not intended as a tool to remove students from schools, but rather to provide them services, understand you know, what may be leading to threatening or violent behavior, and provide that student with the necessary supports and mechanisms to get them on a better pathway. I also wanted to clarify that behavioral threat assessments are very separate in a different, completely different than MDRs. That one does not replace the other. And I would just also note that in the training and the guidance that's provided through the state of Vermont and the guidance on behavioral threat assessment teams is that when initial threat or potentially threatening behavior is reported, before a threat assessment is even started, the first thing the team will do in the initial assessment is to understand or determine if there is an IEP or a 504 for the student. If there is, and the reported behavior is covered under the 504 or the IEP, a threat assessment isn't even started. So I just want to make that clear that, the threat assessments aren't intended to replace that, and that there is a very specific process to determine initially whether an IEP or 504 is in existence. As we know, not all students have IEPs, so a behavioral threat assessment, obviously that works for kids and students who do not fall under an IEP. I just also, again, clarify that the threat assessment process is, again, not an avenue to expel students from school, but rather to identify threatening behavior prior to inaction actually taking place. So it's preventative. And one of the reasons why we have a multidisciplinary team approach is to bring in individuals who have a lot of different perspectives and to bring those perspectives into the threat assessment. So, for instance, the language we have identifies who shall be on the threat assessment team. That's not a limiting factor. Schools can have larger threat assessment teams that include coaches, other staff members, those kinds of things. The language just indicates the members that shall be appointed to the threat assessment team. So it doesn't exclude other folks from being part of that team. So I just wanted to clarify that, and again, the focus is not on, this isn't a disciplinary tool. It's a tool in order to identify areas where we can provide further supports for kids and identify, needs that they may have that can be provided to them. And I also note that, the focus again is on violent behavior, but the threat assessment teams are also used just as much for threats of self-harm, just as important. That, again, if we have kids or students who are, in a situation or feel that they're in a situation where they are indicating they may self-harm, this is also used to provide them with supports and outreach prior to them taking any action with that. So I did want to make that very clear that, again, this isn't a punitive tool. It's an assessment tool to intervene early and prevent acts of self-harm, acts of violence, and those kinds of things. There is also a guidance document that's provided to all of the folks that have gone through the behavioral threat assessment training that the state's provided over the course of the last approximately 6 or 8 months or so. And I believe there are upwards of 500 people who are affiliated with schools, whether that be nurses, mental health professionals, teachers, administrators. Across the board, there's upwards of 500 folks who've been through the training in Vermont already. And as you know, Dr. Randazzo was in last week to testify, and her group is the one who puts on the training. And part of that training is the Behavioral Threat Assessment and Management Guide. And that guide is also on the Vermont School Safety website and is accessible to anybody who wishes to take a look at it. And in that is all of the guiding principles on threat assessments. So there is guidance, there's training that folks go through, and we also have just recently done a train the trainer program so that we have a group of individuals in state who can also conduct the training. But just to go back to guidance, it does exist. It is already on the Vermont School Safety website, and it is part of the training that our Vermont school leaders and behavioral threat assessment team members attend.
Thank you.
My last one, just a couple of those.
Yeah, we
really
have a joint hearing,
I know,
so.
yeah. So quickly, for students who need supports or who are expressing an intent to self-harm, we already have Act 264, which permits coordinated services plans to get students additional supports. Even if the intent here is not to remove students, the reality is that these teams have been used, including in Vermont, to remove students, including this story that I told you earlier. If the intent here is not to be explicit, is not to be punitive and not to remove students, I would strongly suggest if you move forward with this section, that you make that explicit here and prevent that. And I also think that significantly more data collection on the use of these teams to understand and assess whether they are having the same discriminatory impact here as they've had in other states would be absolutely essential. Finally, I would say that guidance is not law. Guidance can and often is ignored. And I don't think one training is nearly enough, and that it would require training and coaching if you were to kind of put the state's imprimatur on these teams. But again, my primary recommendation would be to say, no, there are other ways to meet the needs.
Committee, any final questions or comments for today on this? I'm going to work with Beth on a draft that at the very least will add the data collection and clarify that this is not a, this is not a disciplinary measure or something like that. And then we can kind of come back, take some of your other stuff and keep the conversation going tomorrow.
Sounds good.
Any committee, any final questions or comments for Friday? Okay, we'll leave it there.